And also the First Amendment motion with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Victoria Marie Sanchez who was placed on deferred adjudication in 2020 CR 2715 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 5th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
And extended for a total of 5 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation of condition number 28.
It's fine.
All right, why would I do that? She hasn't been successful.
Because you're merciful and just.
In the heart of a Texas courtroom, a familiar face returns. Victoria Sanchez stands once again before the judge, facing the consequences of a probation violation. Her history with the court dates back to 2020, when she received deferred adjudication for possession of a controlled substance. But now, the court considers whether mercy still has a place. The defense pleads for leniency, citing trauma and personal struggles. But the judge isn't convinced. This is not her first misstep. Subscribe now to Judge Bench for real courtroom stories where justice and redemption collide.
All right, state.
Yes, Your Honor. Violation of condition number 28. On or about the 11th day of April 2025 in Liberty County, Texas, the defendant Victoria Sanchez did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, that the defendant was unsuccessfully discharged for refusing to participate in treatment in violation of condition number 28.
All right, so what motion are you reading from? Because I don't see a violation of 28 on mine.
The courtroom tension builds as the state outlines a single yet serious violation: failure to comply with the SAFPF Continuum of Care Treatment Plan. Victoria Sanchez, discharged for refusing participation, pleads true. Her journey through the system has been long and layered with chances: outpatient programs, drug court referrals, even Zoom check-ins. But at each turn, she faltered. The judge, skeptical of another plea for leniency, studies the documents. This isn't new territory. It's a revolving door. The state pushes for a 2-year sentence. The question now: has time run out?
This was provided, it's under case number ending in 2715.
Is it a supplemental or something?
No, Judge, it was signed 5/13/2025.
May I show the court?
Yes, because I don't have that one. Okay. Yes, I've been given the wrong paperwork. Okay.
Rely on the defense to give you the right paperwork.
Okay. So to that allegation, how do you plead? True or not true?
True, Your Honor.
State, do you waive? Is that the only allegation?
Seeing that this is the only violation.
Defense attorney Ted Wood steps forward, offering a glimmer of hope. He requests the court sentence Victoria to a reduced charge: attempted possession, 180 days, time served, a plea built not on success, but on mercy. He points to trauma, to missed opportunities for healing, and to a mother's desire to rebuild. Because you're a merciful and just judge, he says, appealing not to law, but to humanity. Yet the court has seen this before. Redemption isn't just requested, it must be earned. And history speaks louder than hope.
All right. Yeah, I definitely didn't have the correct paperwork. All right. Did you understand by pleading true to violation of condition number 28, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 28?
Yes, Your Honor.
Court will find violation of condition number 28 true. Is there a proposed agreement?
There's not. We are going open, Your Honor.
All right, state, what are you requesting?
The state is requesting that you grant the state's motion, revoke probationer, and sentence probationer to 2 years TDC.
And defense, what are you recommending?
Judge, right now,
Victoria tries to defend herself, reminding the judge she paid child support, completed parenting courses, and saw her kids regularly, at least for a time. Her voice cracks as she speaks of her son, who's now struggling in middle school. The judge doesn't budge. You know why your son is having a hard time? Because you're not in his life. The words strike deeply. It's more than a sentence. It's a reflection of broken trust, not just with the system, but with a child looking for stability.
This morning, Ms. Sanchez has 180 days credit. I'm asking the court to find her guilty of the lesser included offense of attempt to possess controlled substance 1 to 4, which is a state jail, and sentence her to 180 days in state jail, time served, judgment satisfied.
All right, why would I do that? She hasn't been successful.
Because you're a merciful and just judge.
Yes, but this is not our first motion to revoke.
It's not, Judge, and I think that Ms. Sanchez is...
Her plea becomes personal. Victoria claims this time behind bars has changed her. She insists she's learned the lessons she needed to, but the judge remains unmoved. "You haven't learned anything," he says, noting the pattern. Relapse, violation, repeat. Her child's suffering isn't theoretical, it's real, rooted in inconsistency. In the court's eyes, true change isn't about words in the moment. It's action sustained over time. And that time, in this courtroom, has run out.
Having difficulty utilizing the resources available through SafeP. I don't think that there's any sort of remediation that is available to her that's going to help her move forward with her life. And Judge, I'm asking that you sentence her to 180 days, time served, judgment satisfied, so that she can get out, rebuild her life. Judge, she's a victim of sexual violence, and I'm hoping that when she does get out, that she can link up with Center for Healthcare Services and get some trauma therapy so that she can go forward with the rest of her life.
All right, and you have children?
Yes, Your Honor, I have 4.
All right, and see, that's the problem, because she was here.
The judgment is clear and final. The court finds the violation true and revokes her probation. Victoria is sentenced to 3 years in prison with credit for time served. A request is made for placement in a therapeutic community. It's a measured decision, stern, not cruel. There's no judgment satisfied, no erased record. This is accountability, not absolution. The judge's tone softens only slightly. It's not about punishment. It's about protecting the child, the community, and perhaps giving Victoria one last structure to try to turn her life around.
Placed her on deferred adjudication. I placed her on 2 years deferred adjudication, gave her all the tools that she could need, had her saying, work with CPS, had contacts for her for outpatient treatment, intensive outpatient treatment, did a referral to felony drug court. Then there was a violation and still continued her, did the weekly Zoom reporting to try to get her on track. And then there was another violation, and then she was sent to SafeP. So I'm not going to give you a judgment satisfied. I'm finding, and did you complete the CPS?
Before leaving the bench, the judge offers a rare moment of grace. "If I'm still here when you get out, come back. I'll call someone, I'll help." It's not a promise of clemency, but of connection. It's a reminder that even after hard justice, there's room for humanity. The courtroom, though cold and procedural, shows a flicker of warmth. Redemption isn't guaranteed, but it's not out of reach. Victoria leaves not with sympathy, but with a clear path, should she choose to follow it.
Document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and sign it?
Yes, I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
We can go off the record. When you're released from prison, if you can't find a sober house, if you can't find someone that can help you, if I'm still here, you come back here, I'll pick up the phone, call somebody to try to get help for you, okay?
All righty, thank you.
All right, you're welcome. Good luck to you.
And so, the case of Victoria Sanchez closes, for now. A cycle of addiction, treatment failure, and second chances reaches its breaking point. Yet buried within the stern sentencing, a door remains slightly open. If she truly changes, if she chooses the hard road of healing, the courtroom may one day see a different woman return. One who stayed clean, one who stayed present. For now, justice is served. For more compelling real-life courtroom stories like subscribe and stay tuned to Judge Bench.